Hey y'all, and welcome back to Young Thug Trial. We still have the witness on the stand. Uh, let's see how much he remember today uh, during the trial since he had a long weekend. Let's see, do he remember anything today? Will he be yes ma'am and all day today? And appreciate y'all being here today on a Monday. Uh, let's see what happened today, y'all. See what happened in court today, okay? Uh, don't y'all start. Don't y'all start. Okay. You know, remember last week, the only thing he kept saying, well, no ma'am, he thought that, see, this is what he thought he was gonna do. He thought he was gonna get away. Witness thought that he was gonna get away with uh just saying no ma'am. So they brought him back again today. So and guess what, y'all? Young Thug dropped the hair today. Young Thug dropped his hair down. He looking like a thug today now. He looking like a thug today in court, okay? So he trying to let that dude know that he praying on the dude while he's sitting there uh on the stand. So let's take it from here, okay? All right, y'all. Young Thug about to do his prayer. His we on day 41.
I'm not sure if she's been here before. Another attorney out there.
Wonder what they looking at on their layout time. I'm nosy. But all right then, Thug. Let that hair down, baby. Yeah. Your hair just don't grow out. There go thuggin'. That's my boy though, I'll tell you, but they funny. Thug don't see nothing funny. But y'all, the same witness gonna come up there today. Brian Steele.
Hi, good morning, councilors, interested parties. We're on the record in the matter of the state of Georgia versus Cleef Adams et al. In 22 SC 183572. Mr. Stilwell, Mr. Botts, and Mr. Shard. Good morning, gentlemen. All right, Mr. Williams, Mr. Steele, Ms. Renard. Okay, good morning. All right, Mr. Kendrick and Mr. Weinstein, good morning. All right, Mr. Huey and Mr. Matthews Jr. and Senior, good morning. All right, Mr. Nichols and Mr. Lamar, actually Mr. Gardner, I should say, good morning. All right, Mr. Ryan and Mr. T. Williams, good morning. All right, Ms. Hilton, Mr. Atkins, Ms. Love, and Mr. Brown, good morning. All right. Okay, Ms. Renard, who's that interloper sitting to your left? And why was I not told anything about other people in my courtroom, Mr. Steele?
And good morning to you, sir. Your Honor.
Oh, don't be trying to get over that, man. You're already in hot water. So who do I have the pleasure of now being with you?
Your Honor, sitting next to Mr. Ryan and Ms. Renard is Haley Halti Wagner, Haltiwagner. She is a second-year law student at Georgia State University. I've had the honor of working with Ms.
Hey, baby.
Wagner approximately 2 years. She's a fabulous lawyer, representing the next generation of lawyers, and with the court's permission, we'd like her to sit at the table. Mr. Adams means no disrespect to the court or Mr. Williams or anyone. He is not going to be here today. He is actually in another court the week on a trial. So, can never replace Mr. Adams. I'm not trying to do that, but with the court's permission, that is who is your honor.
Okay. Mr. Williams, you okay with that? Okay, all right. Okay. All right. Mr. Bean outside?
Dear John, before we get started, I'd just like to ask if the court would allow us an opportunity to look at some certifieds that Mr. Steele indicated he has. He indicated he would show us the certified list, and the court came in right before he had an opportunity to do so. So before we bring Mr. Bean, can we just see a copy of the certified itself?
Sure. You all can look at those.
She love to be in that camera, child. Ooh-wee. Fannie Willis girls.
Your Honor, would the court like for us to bring Mr. Bean in before I look at the certified?
No, why don't you accomplish that and then we can bring Mr. Bean. I just want to make sure he was here, that's all.
Okay.
I know, can't even put no food in
Thank
it.
you, Your Honor. We have been able to look at a copy of the actual certified copy of 14 SC 130460. And based on information that Mr. Steele shared with me just now, I don't want to speak prematurely, but it appears that he also has some indictments that he intends to use. And I moved in limine that the court preclude Mr. Steele from attempts at impeachment or improperly introducing indictments that are not certified convictions of this witness or any other. Based on the information that he just gave me when I asked to see the certified copies of conviction, he has only given me one certified conviction for Adrian Dean, and that is for Fulton County Indictment 14 SC 130460.
Okay, so there's no argument about the certified, is that right?
Correct. There's
Okay,
no
all right.
argument about this.
And then what about the uncertified or do we, is that what you're asking me to, or,
Yes.
to pose or weigh in on?
Yes, because I've just been told that Mr. Steele has copies of indictments. I don't know.
You have certified copies of those convictions, sir?
And good morning again. As I told the district attorney's office, there's certified copies of charges of an indictment, not convictions. I told the district attorney I was not planning on seeking to admit them now, but they may become ripe. What happened in two different cases, if you want to know, is Mr. Bean was charged
What's up, Shannon?
serious crimes, armed robbery, I may be a little off here, but armed robbery, trafficking, marijuana, something to that effect. And the cases were dead docketed.
Okay, I got 13 people looking. I need 13 likes.
It's 368 Georgia Appeal 481. Your Honor, that's 890 Southeast 2D 385, 2023 case.
If you're in the chat, please go ahead on and hit the like button. It don't cost nothing, y'all. I appreciate it. I don't know why men so slow about doing stuff. Let me skip this.
Once the indictment is returned in open court by the grand jury, there's not a statute of limitations issue with a dead docketed count.
Again, Your Honor, since Mr. Steele has indicated that this issue is not right, my only request of the court is that before Mr. Steele mentions it, he, at least outside the presence of the jury, tells the court for what purpose he intends to
Let me
try.
ask- Let me ask you a question. Mr. Steele, do you have some basis to believe that the state is
She
offered
needs to
Mr.
stop bending over like that.
Being a deal, or has indicated they're not gonna take these dismissed cases off of the dead docket, or what's your theory of how you might confront the witness?
He would, no, to answer your question directly, no.
Okay.
I don't have any reason, good faith belief that the state is, saying it's coming off the dead docket, but under Ridley, R-D-L-E-Y, that's not the issue. That's exactly why I gave you the case. It goes to the state of mind of the witness who is testifying, and, the jury makes that determination.
The state of mind as to how?
Because what
Really doesn't say that.
Yes, it does. If you
Where in really does it say that?
if
Point to
you
the
started-
page. I want to see it.
Started, the 8th paragraph, which I think is on the 2nd page, Your Honor, and then go to the 3rd page. And, it says in the very top left-hand, I'm going by my memory, but top left-hand corner,
Y'all come on and
should
hit the
say
like button
whether the
for me
witness
now.
is testifying pursuant to a deal with the state is not crucial.
Appreciate you.
I'm going by my memory.
Yeah,
the
that's
right.
pretty close. Okay.
To the right to conduct such a cross-examination. So it's a pending charge. This isn't about a deal. This isn't about conviction.
That man know the law, boy.
I just, got well and straight with the court. I'm just telling you, I understand, that if it was a conviction, I wouldn't be able to use, I have other convictions for him, but they're over 10 years of age. I'm not trying to get those in because I don't think it's right to ask this honorable court to make a balancing test.
So you're saying he's still facing charges, and that's what you want to ask him
Yeah,
about?
that's all that issue is.
All right.
And it has nothing to do with the statute of limitations. It has nothing to do with, a conviction. I'm just doing what I think lawyers should do. I'm just being straightforward.
Your Honor, under 403, given that these are dead document charges in 2011, and I don't believe that Mr. Steele or Mr. Williams has any basis to argue that under Ridley, he should be allowed to introduce this 11SC case in this 06.
That's what Ridley seems to indicate, and it tells me under 403, it's an extraordinary remedy, which should only be used sparingly. So if he wants to ask him about he's facing charges, he's technically still facing charges, and he would be permitted to do that. If it comes up, okay? So, but right now, I would let him do that.
Well, with that being said, then I will do it.
Your Honor,
Okay.
under Ridley, when the court said that he is facing charges,
He's still facing charges. He's got a dead docket. Dead docket stops the statute of limitations. It's still open case. How many employments times have witnesses or other people faced dead dockets, and then because the same thing, because it's still an open case? That's my ruling. Can we move on?
yes, Your Honor.
Okay, all right. If it comes down to it, so, yeah, he's got a good faith basis, so, if it comes down to it, he can ask those questions. All right, anything else?
Not on behalf of Mr. Williams.
Okay, all right. So our name, can you summon our jurors for us, please?
And Your Honor,
Ma'am.
Mr. Steele will not be attempting to play any hearsay. He won't be tendering any.
She talk too much.
Laying any foundation for that.
She just needs to hush. Just have too much to say. Just answer this boy some questions so he can tell the truth. Well, I just don't want to hear just no yes ma'am today.
Ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, good morning. All right, you sound good. Okay, all right. Ms. Love, I believe that we still have Mr. Bean with us, so can we summon him, please?
Yes, Your Honor.
All right.
Oh my God, please don't just say yes, ma'am, today. Same witness,
Mr.
y'all.
Bean, good morning. Come on up again. All right, sir, you're still under oath, okay?
Yes, sir.
All right, thank you, sir. All right, cross. Mr. Steele?
He's sharp today.
Thank you, Your Honor. You were released from prison in approximately 2017, is that correct?
Yes, sir.
And since you've been released from prison, you have been gainfully employed. You've been working, right?
Yes, sir.
And you work for, I believe, currently, and if I'm wrong, just tell us, for the city of Atlanta, is that right?
No, sir.
Who do you work with currently?
I'd rather not say who I work for, sir.
Okay, what do you do currently for a living? How about that?
I'm a foreman.
And explain what type of foreperson.
Foreman.
You said a foreman.
A supervisor.
Okay, for what type of work?
Traffic control.
Okay, traffic control. I'm sorry, I'm having a hard time hearing you. Traffic control?
Traffic control.
Okay. And how long have you been doing that?
I really can't recall.
One more time.
I can't recall, sir.
Has it been more than 2 years?
Yes. Yes, sir.
Okay. And are you working other jobs as well currently?
No, sir.
All right. With regard to your testimony last week, Thursday and Friday, you said a lot of, I don't recall, 2013. Do you remember something like that?
Yes, sir.
And I think you explained or tried to state that that was a bad time in your life, you blocked it out. If I'm misstating that, just correct me.
You don't recall anything from 2013, sir.
And why is that?
I just don't recall. I don't remember. I just don't recall, sir.
Do you remember things in 2014?
No, sir.
No? Yes or no?
No, sir.
2015?
I don't recall, sir.
How about 2016?
No, sir.
2017?
I just remember what I need to remember in 2017.
That's after prison, is that what you're saying?
I mean, I was released from prison in 2017.
And is your memory good after 2017 released from prison? Do you remember whenever month, I don't know the month, you're released from prison, you remember that? Is that what you're telling the jury?
Yes, sir.
And you remember then 2018?
Your Honor, I object as to vague. That's a broad question and not specific
Okay,
enough.
I'll stand the question. Just rephrase, Mr. Steele.
Do you have a memory of things you did in 2018?
Objection, vague.
I'll let him answer the question. I'm over the question. You can answer it, sir.
2018. What I'm remembering in 2018.
You don't?
What am I remembering in 2018, sir?
Anything, where you were working, how about that?
No, I remember where I worked in 2018, sir.
Okay. Do you remember being home in 2018, not incarcerated?
Yes, sir.
All right, how about 2019, same question?
What am I remembering?
Same question.
Every year you asking me, what am I remembering? You ask me about this certain type of year. That's what I'm trying to get you to understand.
Answer my question. Do you remember where you were working in 2019?
No, sir.
Were you working in 2019?
I don't remember.
Were you living free in 2019?
I'm free.
Were you living with your wife in 2019?
I've been with my wife in 2019.
Same questions, 2020. You remember that year where you were working?
I've been doing the same job for some years now, so it'll run into all that. It's 24 now. I've been working by 7, 8 years now. The working part is going to be what you're asking me about, sir.
And you remember that in 2020, right? Yes or no?
Yeah.
And 21, same question.
Okay.
Remember that?
I remember my work 21. I remember my work 22. I remember my work 23. I remember my work 24. This year right now, what we're looking at.
But you don't remember too.
How clearly do you remember 23 and 24 years? This year and last year?
Not too good.
I can't hear you.
Not too good.
Okay.
You ain't lying.
Mr. Bean,
He lying.
you remember being convicted of what has been marked as State's Exhibit number 157C, as in Colette or Charlie, that you identified last week. Do you remember that?
No, sir. I don't know.
Okay. Your Honor, with the court's permission, may I show electronically 157C in Colette? And Mr. Kokomo, if he can help me out.
Woo, they gonna get you today, brother.
It's already in evidence, Your Honor. Yes, sir. It should be on the screen. You can look behind you or right next to you in a moment.
I'm still gonna eat you up today,
I want to go
brother.
through this with you. Okay, Mr. Bean, what's on the screen is been already admitted on March 1, 2024. This is the Superior Court of Fulton County, State of Georgia versus you. You see that on the left-hand side of that first page?
Yes, sir.
And you see where it says filed in the office of the Deputy Clerk of Superior Court, Fulton County. It gives the date of October 15, 2015.
It's going to still be the same, man.
I can't hear you.
It's going to still be the same. I seen this paper last week. The same paper Ms. Love showed me last week.
I just cannot hear you.
Friday. It's going to be the same thing. I seen this paper before.
Answer my question. Do you see it says October 15, 2015, filed in the office of Deputy Clerk, Superior Court, Fulton County?
Yes, sir.
And you see in the next column to the right, there's a rectangle and it has your date of birth, June 22, 1979. True?
True.
Okay. And then if you go down on that page, with Mr. Kokomo's permission, you see it lists certain charges on the left-hand corner. You see that? Left-hand side?
I know
It
that's
goes
right.
from
Shit.
1, 2, 3, 4, 5, 6, and then it skips to 9. You see that?
He gotta see it. Won't he open up his mouth?
And then it says in the disposition, you see 2 columns over, after it says charge, and then you see disposition.
Yes, sir.
And on count 1, it says guilty Alford. Right?
Talk.
I don't know.
Do you see it?
You see it right there?
I can't hear you.
I don't know.
Do you see it? Is
I
what I'm
can't
asking.
really see it.
Yes?
Okay. Where you thing at? Yes, sir.
Okay. And then it says for the sentence, 10 years to serve 3 years. That's in prison, right?
Okay.
Balance probated 7 years, right?
Okay.
And then it says concurrent with, and it gives another indictment number. You see that?
Okay.
And that's indictment number 14 SC 130460, which we're going to discuss in a moment. All right? Okay? Yes?
Why he acting like he can't talk
This
now?
is October 15, 2015, and the total sentence here is 10 years, right?
I don't recall this.
Well, that was your sentence.
I don't recall this.
Okay. This is the same document you recalled last week on the 1st of March, right?
But I still didn't recall it.
All right. Count 2, you see on the left-hand side, count 2, it says aggravated assault against a police officer, vehicle on vehicle. You see that? You see that?
Yeah, I don't recall none of this paperwork right here, but you're showing me though, Mr.
All right, well, it's in evidence, so we're going to go through it. Again, you pled guilty under Alford, right? And the same sentence. 10 years is total sentence, 3 years in prison. The balance is 7 years on probation to run concurrent with count 1. Okay? That's what it says, right? Yes or no?
Sir, you gotta answer the questions, okay?
Yeah, I guess it's on the screen. Yes, sir.
Count 3 is again aggravated assault against a peace officer. And again, guilty under Alford, 10 years to serve 3 years, balance, 7 years on probation, concurrent with count 1, right?
I never pleaded to this.
All right, we're going to talk about it. We'll go through the whole document. The next one is count 4, 5, and 6, and that's armed robbery, aggravated assault with a deadly weapon, and possession of firearm during the commission of a felony, and all those were no pros were dismissed. You see that?
Yes, sir.
All right, and then the last one is count 9, fleeing or attempting to elude, misdemeanor, and again, guilty under Alford, 12 months to serve concurrent, run at the same time as count 1. That's what it says, right?
That's what it says.
All right, let's go to page 2 with Mr. Kokomo's permission. And these are the terms of the sentence summary. You see that right there where Mr. Kokomo stopped? You see in bold it says sentence summary. And these are the terms of the sentence summary. You see that right there where Mr. Kokomo stopped? You see in bold it says sentence summary.
Sentence summary, yeah.
Okay, and defendant is a word used for somebody charged with a crime, right? You know that?
I didn't know that.
Like a plaintiff is a state or a defendant.
See, he
person
can't
charged
just
with a
say
civil
yes,
case.
ma'am,
You know what
today.
I'm talking about?
No, sir.
No? Okay. Well, as a defendant is a judge guilty. Excuse me, I'm in the wrong place. The defendant is sentenced for a total of 10 years, with the first 3 years to be served in confinement, the remainder to be served on probation, right? Then it says or, and that it's not checked, to be served on probation. So you were sent to prison, right? You see that?
Answer the question.
You say so.
That's the prison you're talking about with the jurors.
Maybe if he
You
say
said you got
something.
out in about 2017, right?
Yes, sir.
All right. And then if you go down to the next line, the defendant, which is just the way it's termed, but you are to receive credit for time served in custody as determined by the custodian. That's the Department of Corrections for the state of Georgia, right?
Answer the question.
You see that?
What's wrong with this dude? Say something,
And
Judge.
then on the next one, which is box 2, it's checked. Upon the service of 3 years, the remainder of the sentence may be served on probation, provided that defendant shall comply with the conditions imposed by the court as part of the sentence. And then it goes through general conditions of probation and special conditions underneath. Okay? You see that? All right. And then Mr. Kokomo
Mm-hmm. You supposed to say yes or no.
can scroll down and it's checked or X, number 2. Probation supervision fee is waived for the first 6 months after release. You see that?
Yeah.
And then on the next page,
Yeah.
it says special conditions of probation. And you waive your 4th and 5th Amendment rights, meaning you have to answer questions. Right? Do you know what the 5th Amendment is?
Your Honor, I object as to the commentary about having to answer questions.
I sustain the objection.
Do you know what the Fifth Amendment is?
I sustain the objection.
For the Fifth Amendment? Ask him if he knows what it means. Okay. You waived your Fourth Amendment and Fifth Amendment rights. You see that?
I'm looking at it.
Okay, and then maintain employment, undergo regular random drug screens, obtain a GED, and then back to that court if your probation is going to be revoked. You see all that?
I'm looking at it.
And revoked probation means you go back to prison instead of being out on the street under supervision of a probation officer, right?
I guess so.
You don't want to go back to prison, do you?
You sure is tripping.
What do you mean?
I cannot. I'm
What do
asking
you mean, sir? Do I want to go back to prison?
You don't want to go back to prison, do you?
If I had to go, I would. I went to prison.
Do you want to go back?
I've been to prison before.
Did you enjoy prison?
I sustain the objection.
I mean, I did mine. I did my time.
Underneath that, if Mr. Kokomo comes down,
You know, Mr. Steele about to burn him.
you hired a lawyer, go down a little more, named Ed Adams. You see that by employment?
Yes, sir.
Okay. And then that court was the Honorable Judge Downs, who sentenced you. You see that?
Yes, sir.
Now, Mr. Williams never paid for any of your lawyers, right?
No, sir.
He never made any bond for you, right?
No, sir.
The next page of this document, 157C, as in Colette, Charlie, keep going down, is the indictment. I want to go through the indictment with you. Okay. If you go up a little bit,
Shelly, I got a new
go
laptop.
down just one more to get count 9. Now, on this indictment, Mr. Bean, in State's Exhibit number 157C, as in Colette, Charlie, you see the indictment number there in the center, written in 13SC 12 2087. You see that?
And that's what it says.
And it says State of Georgia versus, and the first person is you. We count 1, 2, 3, 4, 5, 6, and 9. Same counts that we just discussed on the sentencing page. You see that?
That's what it says.
And then you have the next person charged is Walter Murphy. You see that name?
Yeah, that's what it says.
And he's the same Walter Murphy that you discussed earlier, according to, you said you didn't recall, but he was referred to by the Honorable District Attorney as DK. You remember that?
No, sir.
Yes.
And he is also charged with you in count 1, 2, 3, 4, 5, 6. Mr. Murphy's charged in count 7, but also in count 9. You see that?
That's what the paper says.
And then the last person is Frederick Medina, which is Medina, Prothro, Prothro. You see that?
Yeah, that's what it says, sir.
And Mr. Prothro is also charged in similar counts as you, but count 8. So he's charging 1, 2, 3, 4, 5, 6, 8, and 9. You see that?
Mm-hmm.
I guess that's what it says.
And this indictment was filed, if you go down a little bit, Mr. Kokomo,
Mr. Kokomo. October the
originally
1st.
October 1, 2023. You see that?
2013, not 23.
It says 13.
You see that? I couldn't hear you.
I said it says 13.
Okay. And then For Walter Murphy,
Okay, Shirley.
you see where he pled guilty to count.
Objection, Your Honor, as to, having this witness testify about someone else.
I sustain the objection.
The documents and evidence.
It doesn't make sense, Mr. Chair. That's a proper objection. I'm sustaining.
All right. Let's just, before we leave this page, just go up a little bit, Mr. Kokomo. Show the jurors where Jeffrey Williams is charged, along with you, Mr. Prothro, and Mr.
Thank
Murphy
you.
in this indictment.
Jeffrey name not even on there. Y'all lying on that boy.
You show me.
I cannot hear you.
You can see it clear as day. It's on the paper. You
Oh.
show me. He's not there.
He's not there. Now, October 1, 2013, the return of this case, that is after you spoke with Detective Quinn at the City of Atlanta Homicide Office on recording on September 17, 2013. You realize that?
No, sir.
All right, if you can scroll down, Mr. Kokomo.
No, you ain't gonna sit there and say no, sir. Today you gonna talk today. You are.
And Mr. Bean, this is the next page.
Name ain't nowhere
And
on
you
there.
see in the top, just talk about you. So I'm excluding the first column, Mr. Prothro, the second column, Mr. Murphy. We're going third column to the right on the top. You see where you originally pled not guilty with your lawyer, Ed Levance Adams, and your signature, you see that?
Yes, sir.
And that's, it says October 29, 2013. You see that?
Yes, sir.
And then if you go down, and it's on an angle on the side, or actually it's on the center right. You see where it says Adrian Bean with your middle name? You see that in the center, kind of right?
But
That's what it said.
And you see
Show
there's a check
name.
mark. You pled guilty under offer to the indicted offenses in count 1, 2, 3, and 9, like it says on the first page of 157C. You see that?
Yes, sir.
And that's October 1, 2015 now. So it's 2 years and 3 weeks after September 11, 2013 that you're resolving this case. You see that?
That's what the paper say.
One more time.
That's what the paper say.
Okay.
he got old.
And then the other counts,
Nasty attitude.
if you look kind of on an angle, as to Adrian Bean, count 4, 5, count 4, 5, and 6 is no pros. No pros means dismissed, just like it was on page 1. You see that?
I don't see it.
Mr. Kokomo, can you just orient Mr. Bean? You see where that pointer is?
Okay, sideways though.
And that's also October 13, 2015, right?
I can't really see it.
Yes?
I can't really see it. Yeah, I see it. It's the bottom.
You see it? Yes?
Yeah.
All right. The next page of this document is the actual charges that you were facing along with Mr. Plethro and Mr. Murphy. And you see the names of the grand jurors in the center. It says a grand jury selected, chosen, and sworn for the county of Fulton to wit, and they charge you. You see that?
What the paper say.
And count 1 charges you, Mr. Murphy, Mr. Medina, with the offense of aggravated assault against a peace officer for that the accused, that's you, and the other 2, in the county of Fulton, state of Georgia, the 11th day of September 2013, did intentionally drive and steer a motor vehicle at, towards, and in the direction of E. Robertson L., a peace officer employed by Atlanta Police Department as a police officer who was at the time of the said assault, engaged in the performance of his official duties as a peace officer, said motor vehicle being a means likely to cause serious bodily injury when used offensively against a person. You see that?
It's on paper.
Okay. And you were driving that 2004 Nissan Altima vehicle at the
Yep.
time that you almost killed Officer Robertson, right?
I don't recall it, sir.
Okay. You knew Officer Robertson L before September 11, 2013, right?
I don't recall it, sir.
And on this one count, you entered a plea under Alford, and we'll discuss what that means. 10 years to serve 3 years in prison, right?
Yeah, I don't recall it.
October.
Oh, Nate trying to act crazy.
I don't really remember anything.
All right, let's go to count 2. This charges, again, the grand jurors charge you, Mr. Murphy, Mr. Plethro, with the offense of aggravated assault against a peace officer. It gives a code section. You know what OCGA stands for?
No, sir.
You do?
No, sir.
Okay. For said accused, that's you, Mr. Plethro, Mr. Murphy, in the county of Fulton, state of Georgia, on the 11th day of September 2013, same day, did intentionally drive and steer a motor vehicle into and against the motor vehicle, which was then and there occupied by A.C. Booker Higgins, a peace officer employed by City of Atlanta Police as a police officer, who was at the time of said assault engaged in performance of his official duties as such peace officer, said motor vehicle being a means likely to cause serious bodily injury when used offensively against a person. You see that count?
And that's what the paper said.
And you pled guilty under Alford and were sentenced on that count, right?
No.
You didn't plead guilty?
No.
What?
No.
Okay. Count 3. Grand jurors again charge you, Mr. Murphy, Mr. Plethro, with the offense of aggravated assault against a peace officer for said accused, County of Fulton, State of Georgia, on the 11th day of September 2013, did intentionally drive and steer a motor vehicle into and against the motor vehicle, which was then and there occupied by B. Porter, a peace officer employed by Atlanta Police Department as a police officer who was, at the time of said assault, engaging in performance of his official duties as such peace officer, and motor vehicle being a means likely to cause serious bodily injury when used offensively against the person. And you pled guilty to that and were sentenced, right?
I don't remember.
Okay. Then count 4 is going to be no process against you, but the charge is that you, Mr. Murphy, and Mr. Plethro were charged with the offense of armed robbery, for that you all, in County of Fulton, State of Georgia, the 11th day of September 2013, did unlawfully with the intent to commit a theft, take from the person and immediate presence of Derek Dotson, United States currency, the property of Derek Dotson by use of a handgun, an offensive weapon. That case for you was dismissed, right?
I don't remember.
Or no process.
I don't remember still.
All right. Mr. Kokomo, just go back to the very first page of State's Exhibit 157 for a second, please. And scroll down to count 4, 5, and 6. You see count 4 armed robbery we just read, and then it says in the third column disposition no process. You understand that? The same with count 5 and 6.
What the paper says.
Okay. Let's go to count 5. What was dismissed against you? You were charged in count 5, along with Mr. Murphy and Mr. Plethro, with aggravated assault with a deadly weapon for said accused in County of Fulton, State of Georgia, on the 11th day of September 2013, did unlawfully commit an assault upon the person Derek Dotson by shooting towards Derek Dotson with a handgun. same being a deadly weapon. Your case was dismissed, that's what you were charged, right?
Yes, sir. The papers say.
And then count 6, it's going to be the grand jury's charge you, Walter Murphy, and Plethro with the offense of possession of a firearm during the commission of a felony for that said accused, the 3 of you, in the county of Fulton, state of Georgia, on the 11th day of September,
Excuse me.
2013, did unlawfully have on and within arm's reach of accused person a handgun during the commission of a felony against and involving the person of another, to wit, armed robbery, and that case against you was dismissed, right?
That's what the papers say.
Okay. And then number 7 charges just Mr. Walter Murphy with possession of firearm by convicted felon. Count 8 charges Mr. Plethro, possession of firearm by convicted felon. And then count 9 charges you, Mr. Murphy, and Mr. Plethro with the offense of fleeing or attempting to elude for that said accused, County of Fulton, State of Georgia, 11th day of September 2013, did willfully fail to bring his vehicle to a stop after being given a visual hand signal to do so by E. Roberson L., a police officer employed by Atlanta Police Department in uniform, prominently displaying his badge of office in an appropriately marked police vehicle. And you pled guilty under Alford to that, right?
I don't remember.
The next page has again your name, your date of birth, as 6/22/79, and then Mr. Murphy and Mr. Plethro's information. And then if you go down to the witness list, you see the witnesses, Derek Dotson, and then the police officers, including Detective Quinn. You see that?
Yes, the papers say.
Okay. Now, that same day, you disposed of another case. You remember that?
No, sir.
Your Honor, may I approach?
You may, sir.
May I approach you? I'm showing you what I marked as dated today, Mr. Wayne, number 199. You can look at the whole document, okay? I'm not trying to rush you. I mean, this is your signature.
No, sir. I didn't write that. I didn't write that.
Is that your signature?
I didn't write down one of those.
Is your lawyer, you recognize the signature of Ed Adams? That's your lawyer?
I don't know how his signature would be, sir.
Is that your lawyer?
Yeah, that was my lawyer, but I can explain to you about his signature.
And do you remember being charged and convicted of aggravated assault with a deadly weapon for an incident on September 7, 2012, did commit an assault by shooting a person named Cameron Brown? Remember that? I can't hear you.
No, sir.
You deny it.
I mean, if that what the paper said, I don't remember that. I don't remember nothing back then.
Do you remember being charged in count 2 with aggravated assault with a deadly weapon on the same day, September 7, 2012, by committing assault on James Butler by shooting James Butler?
No, sir.
You deny it.
Yes, sir.
You do realize you're on an oath.
Yes, sir.
Remember count 3, being charged and convicted of possession of a firearm by a convicted felon on the seventh day of September 2012, did knowingly and unlawfully.
I don't remember that from Steve.
You had a firearm, to wit, a handgun. You were a convicted felon from indictment number 01SC03786, Superior Court, Fulton County, charged with possession of cocaine with intent to distribute on May 18, 2021. Are you denying that?
Sir, I don't remember that, sir.
And then on the last page, it has, again, your name, your identifying information, including 6/22/79 as your date of birth, right?
That's what the paper say.
Your Honor, I have a certified copy of a conviction from the Honorable Fulton County Superior Court Clerk for State of Georgia versus Mr. Adrian Bean, same lawyer, same date, judge down. I have a plea colloquy if you want it. And in fact, I have same date of birth on the document itself, and I move it into evidence.
Have you shown that to the state? What are
Of
you
course.
arguing as, sir?
Mr. Williams, number 199.
Any objection, Mr. Williams, 199?
State has no objection to the self-authenticating document that is the certified conviction, that is Williams 199. I'm not certain what the rest of Mr. Steele's representation is regarding the policy, but the certified conviction the state has no objection.
All right, I'll admit, Jeffrey Williams, 199, the actual certified copy of the conviction. The other allied documents can be separated, okay?
Your Honor, may I approach Mr. Bean with Mr. Williams, number 199, that's in evidence, as well as states 157C, in case he needs to refer to them.
Yes.
May I approach you again?
Thank you. Yes, sir.
I'm showing you, and I'm going to leave with you, in case you need to see them, just let us know if you're looking at them. This is Mr. Williams, number 199 in evidence, this is state certificate number 157C. Okay. With Mr. Kokomo's permission, Your Honor, I would like to show on display Mr. Williams, number 199, that's now in evidence.
All right, there you show.
He thought he just gonna say no sir today, but they set you up.
Okay, Mr. Bean, we are looking with Mr. Kokomo's permission at Mr. Williams, number 199. It's on the screen. It's also right in front of you, if that's easier for you. You can look at either one. And at the top of that, on the left-hand side, again, it is State of Georgia versus you, Adrian Bean. You see that?
Oh boy. Why he acting like that?
Excuse me. Can I say something?
Not really. Answer my question, and then you ask the Honorable Court.
Is that what the paper say?
What'd you say, sir? I'm sorry.
That's what the paper say?
And then this is for indictment number, you see under it, criminal action number 14 SC 1306, 0460. You see that?
Yeah, that's what the paper say.
All right. And Mr. Bean, to the right of that, you see in that rectangle, it's the same date of birth for you, 6/22/79, right?
6/22/1979 been stated to be my birthday. Yes.
Okay. And then underneath it, we are going to go to the charges. You entered a plea. It says a non-negotiated plea. You see that check mark right in the center top? Or it's not a check, it's an X.
That's what the paper say.
Okay. And then a little down, you're charged now in 4 counts in this indictment. And the first one is aggravated assault with a deadly weapon, as well as is the second count. The third count is possession of a firearm by a convicted felon, and the fourth count is possession of a firearm during the commission of a felony. You see that in the second column on the left?
That's what the paper say, sir.
And then in the center, well, it's center left, you see the disposition? You again entered a guilty plea under Alford to all 4 counts. You see that?
That's what the paper say.
And then next to it is your sentence. And you see the sentence now is 10 years to serve 3 years, balance of 7 years on probation. And that's to count 1 as well as count 2. You see that?
That's what the paper say, sir.
And then on the far right-hand corner, that says concurrent
with the indictment number, which is in State's Exhibit number 157C, as in Colette, indictment number is 13 SC 12207. You see that?
That's what the paper say.
And then for count 3, and you get 5 years to serve 3 years, balance of 2 years probated. You see that?
Yeah, that's what the paper say, sir.
And that's concurrent with count 1 as well. Right?
That's what the paper say.
Okay. And then on the last count, it says 5 years to serve, suspended, consecutive to count 1. You see that?
Yeah, that's what the paper say.
And consecutive, you know, means run after, right?
I don't know what the consecutive means, sir.
All right, well, the sentence summary, if Mr. Kokomo goes down. The summary is that you, the defendant, is sentenced for a total of 15 years. The first 3 years to be served in confinement, the remainder to be served.
On probation. Are to be served.
And then if you go to the next page, at the very top, you are to receive credit for time served in custody as determined by the custodian. And then number 2 is checked upon the service of 3 years in prison, upon the service of 3 years, the remainder of the sentence may be served on probation, provided the defendant shall comply with conditions of probation. And when you go down, Mr. Kokomo, they're going to be the same conditions that we discussed earlier for your other conviction in State's Exhibit 157C. You see that?
And that's what the paper say.
All right, and then if you go down to the date, keep going down, please. And there again, you're represented by your lawyer, Ed Levance Adams, by employment, and that's the 14th day of October, 2015. You see that?
That's what the paper say.
The next page is going to be your indictment. This is 14 SC 130460, charging you, Mr. Bean, with those 4 counts, 2 counts of aggravated assault, possession of firearm by convicted felons, count 3, possession of firearm during the commission of a felony.
Oh,
This
when
was
there's nowhere
returned
around on the
October 24th,
crime.
2014. You see that?
Yeah, that's what the paper say, sir.
And underneath that, it is stamped there, October 24th, 2014, same day the grand jury returned the indictment. And if you go down, you had first, on December 22nd, 2014, entered a not guilty plea. That's on the left-hand side with your lawyer. And then in the middle of that page that Mr. Kokomo is showing, you change it to a guilty plea under Alford versus North Carolina to all counts on the first day of October, the 15th day of October, whatever that says, 2015. You see that?
Yes, sir.
And then you see underneath it's filed in the office of the clerk of Fulton County Superior Court on October 15, 2015, the same day as you were sentenced on the other September 11, 2013 crimes, right?
That's what the paper say.
And then on the next page, it shows the grand jurors charged you, and then in count 1, this indictment is only you. You're the only person in it, right?
How many times we're gonna look at it?
One more time.
How many times we're gonna keep looking at the same paperwork?
You're the only one charged, right?
I ain't charged. I mean, how many times we're gonna keep looking at the same paperwork that you're showing me?
You're the only one charged. Answer the question, please.
That's what the paper say.
And then it says in count 1 that the grand jury does charge and accuse Adrian Bean with the offense of aggravated assault with a deadly weapon for that said accused, County of Fulton, State of Georgia, the 7th day of September 2012, did unlawfully commit an assault upon the person of Cameron Randolph
by shooting him with a handgun, same being a deadly weapon. You see that?
Woo-wee.
That's what the paper say.
Count 2 that you pled guilty to under Alford charges you with the offense of aggravated assault with a deadly weapon for said accused in the county of Fulton, state of Georgia, on the 7th day of September 2012. Did unlawfully commit an assault upon the person of James Butler by shooting him with a handgun, same being a deadly weapon. You see that?
That's what the paper say.
Now, this is approximately 4 days short of a year from then, is September 11, 2013, when you were driving that red 2004.
Wow.
Right?
I don't recall still.
The next,
I don't recall still.
the next count is count 3, charging you with possession of a firearm by a convicted felon in the county of Fulton, state of Georgia, on the 7th day of September 2012, did knowingly and without lawful authority possess a certain firearm, to wit, a handgun. Accused having been convicted of felony on indictment number 01SC 03786, Superior Court of Fulton County, charge of possession of cocaine with intent to distribute on May 18, 2021. Right?
That's what the paper says, sir.
That's about 11 years
Catch me.
earlier than September 2012, right?
I guess that's what the paper say.
And you told the jurors that you've been through the prison system several times. Didn't you say that today?
Today?
Didn't you say that?
I said I've been in prison before.
All right. And then count 4 charges you possession of firearm during the commission of a felony for that you, or as accused, excuse me, in the county of Fulton, state of Georgia, on the 7th day of September 2012, did unlawfully have on and within arm's reach of accused a person a handgun during the commission of a felony against and involving the person of another, to wit, aggravated assault, and you pled guilty to that, right?
I don't remember.
All right, and then on the next page, it shows the witness, it shows your name and information, or some information, again, giving you date of birth as 6/22/79, and then the witness list against you, and you see that Mr. Billingsley, Mr. Butler, Mr. Randolph, and then those police officers. You see that?
Yeah, that's what the paper say.
All right. Now,
You were
Mr.
driving that car. You driving that red car. Golly.
I noticed several times on last Thursday and Friday that you were given a choice. Is your answer you do not recall information on statements that you gave on recording to Detective Quinn on September 17, 2013? Or are you saying you did not?
Yeah, I don't recall.
And you specifically never said that you denied that it occurred. You just kept saying, I don't recall. Remember that?
That's what I said.
Now, you know and remember September 11, 2013. The I don't recall is not true. You are not being honest to the juries. Am I right?
I don't remember, sir.
What?
Do you recall
Something wrong with him.
meeting with me and investigator James Martin, private investigator? And we were trying to get in touch with you. And we caught up with you on Sunday morning, approximately 11 o'clock in the morning, on January 22 of 2023. You remember that?
Yeah, I don't really remember, though.
Do you remember saying,
You need to go back to jail.
I'll speak with you, but let's go to the nearby Kroger. Remember that?
Something like that. I mean, I don't really remember the conversation, though.
Do you remember Investigator Martin and me asking if we can record the conversation with you?
Okay.
Do you remember giving permission and said, that's fine?
Okay.
Do you remember me telling you, I only want the truth?
Okay.
Do you remember?
Your Honor, as to this.
You have an objection, ma'am?
Objection as to
Basis?
hearsay, the questions haven't been posed.
I think he's gonna ask them, so at least, is that your intent, Mr. Steele?
I have to lay the foundation.
Your Honor, I'd like to approach us to the foundation.
Y'all sit up there and lied on Young Thug. Man, y'all don't even care nothing about that boy. Told that police 911 that he ran in somebody's house and he wasn't even in the car. Y'all ought to be ashamed of yourself, boy. It's a shame when people don't like you, they just make up lies on you, man. They need to let that boy on out of there. He wasn't even with them old thug when they hit that wall. That's a shame. Sitting up there blaming that dude like that, man. I believe they took advantage of Young Thug because he just a nice person. Well, I be done sit up there and lied on that boy. That's sad. They don't like him like that. A shame. And he's sitting up there just lying the whole time up there. Mm, mm, mm. Mm, mm, mm. Shame. Lied on that boy. He ain't got nobody on his side. All them old thieves probably tried to steal from him. And he the driver. The witness up there on the stand is the driver of the car. And they already on dead this time. So why are we here with a RICO? I don't understand it. Why are we doing a RICO and they did the time for this stuff? Golly. They just lying on Young Thug. Oh, Lord. Come on, y'all, man. I'm going to skip it, y'all. Woo! Hold on, let me hear him lie.
You.
No, sir.
Do you remember lying that the driver's not you and saying that the driver was your dear friend, Fred Plethora?
No, sir.
Fred Plethora and you are good friends, fair to say, or were good friends?
I don't recall, sir.
You don't remember stating that Fred Plethora is like your brother?
No, sir.
You've been arrested and indicted with Fred Plethora in the past, right? Only the September 11, 2013 case, but other case, right?
No, sir.
You deny that?
Yes, sir.
This boy right here just a compulsive liar. He need to go back to jail. He under oath.
To be fair to you, and maybe it doesn't need repeating.
I don't remember no case from
Let me just finish speaking.
Further protocol.
Let me just finish speaking, then, what did you say? I apologize. What did you say?
Same thing I've been saying.
Okay. I didn't hear what you just said about Fred Plethora.
I don't remember no case with him. Being indicted with him. No, I don't.
Oh, he got a bad attitude. Need to chill out before you be going to jail again. He about to wear you out. You're not done yet. It's not over.
Let me show you what I've marked as Mr. Williams number 200, exhibit number 200.
Watch this. And talking about he's supervisor.
I object to this and I would like to approve.
I wish she'll hush. She don't got a new dress on. She don't want to sit down. Got that new dress on. Look how thug looking at him. Like lame.
May I approach Mr. B?
You may.
May I approach you, sir?
Sir.
Say yes.
Yes, sir.
Showing you what I've marked and today's date, Mr. Williams, exhibit number 200. Take a look at that. Tell me if you recognize what is in Mr. Williams number 200.
Why he gonna say he don't call? That's what the papers work said. I meant to say that's what he gonna say.
Recognize it?
I don't recognize none of it.
Okay. Your Honor, I move for the admission of Mr. Williams number 200, a self-authenticating certified copy of the indictment from the Honorable Clerk of Court, Fulton County. Indictment number 11, SC 102083 for purposes of impeachment. Any
Ooh.
objection, Ms. Law?
It's admitted, may be inquired upon as you see fit.
Mr. Kokomo, thank you so much. All right, this is Mr. Williams on the screen. It's also in front of you, sir. This is indictment number 11 SC 102083. You see that in the center top part of this page?
That's what the paper says, sir.
And you see it's State of Georgia versus a gentleman, Mr. Frederick Prethrow, counts 1, 3, 4, 5. You see that?
That's what the paper says.
Then a William Herman Green with an E at the end. You see that?
That's what the paper says.
Also, Shudwana, if I mispronounced, I apologize. Shajuana Bean, same last name as you.
Gianna.
That's what the paper says.
And that's count 1, 3, and 4, right?
That's what the paper says.
And who is, if anyone, in relation to you, that person?
Objection, Your Honor.
His wife.
I sustain the question you remember when you asked about Mr. Steele.
All right. And then your name is at the end. See, Adrian Bean, count 1, 2, 3, 4, and 8. You see that?
That's what the paper says.
Okay. And on the right-hand side, it gives the charges. You see that? 1 through 8.
Yes, sir.
Possession of marijuana with intent to distribute, possession of cocaine with intent to distribute, possession of firearm during commission of a felony, possession of firearm during commission of a felony again, possession of firearm by a convicted felon, possession of firearm by a convicted felon again, count 7, obstruction of a law enforcement officer misdemeanor, possession of firearm by a convicted felon. You see that?
Yes, sir.
And then you see, if you go to keep going to the right part of that page, it's written at an angle. You see that it says that upon the motion of the assistant district attorney, the within indictment is ordered placed on the dead docket, and the surety, meaning bondsperson, is relieved.
Come on, Kokomo, fist the paper.
It's the 25th day of July, 2011. You see the judge signature, and that says as only to you. You see that?
Yes, sir. What the paper says.
Okay. And then on the next page, it has people's guilty or not guilty. On the next page, which will be the third page of this document, these are the charges that we just discussed. And I'd like to just look at,
Your Honor, I would object to the presentation of the details within the document and proper use.
documents and evidence, and it's a dead docket pending
Mr.
case.
Steele, same thing. If she's objected, it's a valid objection. Remember what you offered it for.
It's a dead docket.
I'm sustaining the objection.
Understood. Then turn to page, please, where it says, at the very bottom, witness list. Do you see that?
Your Honor, once again, I object to Mr. Steele getting into the specifics.
I sustain the objection.
Your Honor, I am showing that a witness in this case is Officer Robertson L. Robertson L. I'd like to impeach the witness. I didn't know who that was.
Your Honor,
That's not what you offered it for, so I'm going to sustain the objection. Remember what you told me you were going to offer, what you offered the document for. I'm admitting for that reason only.
Okay. All right. Mr. Bean, does this change your testimony in front of the jury that you've never been charged or indicted with Mr. Frederick Prethrow again? Or besides the September 11, 2013 case?
The document you show says that. I don't remember.
All right. And Mr. Prethrow was a close, dear friend of you in the early 2010, 11, 12, 13 period. True?
Your Honor, I object to that compound question.
I sustain as to form. You can rephrase, Mr. Steele.
You considered Mr. Prethrow a close friend in year 2011, right?
No, I didn't, sir.
2012?
No, I didn't.
You know they
2013.
fake. They fake friends.
I didn't remember.
Did you say
Go
something?
ahead.
Did you say something?
No, sir.
Did you remember telling, and didn't you tell Detective Quinn on September 17, 2013, that Fred Prethro was like a brother to you?
I don't remember any questions that I had with Detective Quinn, sir.
Do you remember telling me and Investigator Martin on January 22, 2023, that Fred Prethro was very close to you?
I don't remember that either, sir.
Y'all just gonna let
Why
him
did
lie?
you tell the detective with City of Atlanta Police Department homicide at the hospital before you go to the Fulton County Jail?
Your Honor, I
on
object.
basis-
That's not an evidence, and I really object to that. This is asking a witness about something that isn't an evidence and will not.
His statement, Your Honor.
Your Honor.
I'm
There's,
gonna overrule the objection. Go ahead and ask the question, okay?
Yeah, I mean, I remember
Why
that,
did you
Vladimir.
tell the detective at the hospital, Grady Hospital, on September 11th, 2013, that it was not you, but your dear friend driving that Nissan vehicle?
there are no facts that are in evidence, there will be no statement put in evidence.
That,
So I object to facts not in
Did
evidence.
he make the statement, Mr. Steele?
yes.
Mr. Steele does not have any such statement. And there is no evidence that will say it.
Can I see it?
Yes, sir.
Let me ask it this way. Do you have a good faith basis?
Yes, sir.
All right, I'm gonna overrule the objection.
Do you remember at time of 44 minutes, 56 seconds on September 11th, 2000, that's wrong, I apologize. Do you remember on September 17th, 2013, on the recording with Detective Quinn at 44 minutes and 56 seconds, telling Detective Quinn that, yes, sir, I lied to the detective when they first came and talked to me, and I told them, and that's probably the lies you're talking about. I told them Big Fred was driving, and I was the driver. Big Fred was the passenger. Do you remember saying that?
No, sir, I don't remember that, sir.
Why did you tell Detective Quinn on recording at that time, stamp that I just said, that your dear friend is driving the car that almost killed a police officer?
I don't recall that, sir.
They need to lock him back up.
Why did you tell Detective Quinn that you typically use your cousin's name when getting arrested so you don't get arrested and they pull
Woo!
up your history?
I don't recall that either, sir.
Why would you use a cousin or any other person's name so you could get out of trouble but get them into trouble? Why would you do that?
I don't recall that either.
Evil man.
When at the hospital,
Your Honor, I object to the hospital statement because that is the part that is not in evidence and that will not come into evidence.
Is there a statement?
yes, sir.
Show it, Miss Love. You have a good faith basis, that's fine.
I sent it to Miss Love this morning before 6 o'clock a.m. It's a 10-minute recording.
It is not a statement at the hospital. It is a statement of Mr. Steele in 2023.
Mr. Bean admits to making that statement at the hospital. This is all proper.
And you probably need to orient him to before you ask that question.
Okay. Your Honor, can Mr. Kokomo come forward with headphones and play the 10-minute recording for Mr. Bean then?
I think you need to ask him some more questions in order to do that.
Okay.
Woohoo! You messing with the wrong one, brother.
Do you remember
Get
having
him,
the
Steele.
ability to make a phone call or phone calls from the hospital from non-recorded lines to your wife, Courtney Bean?
I object to facts not in evidence. Here's, as Your Honor.
I'll sustain the objection. Why don't you lay a little more foundation, sir?
Have you, when you were prosecuted for this case that you're here about driving the You pled guilty about driving the, you pled guilty under Alford for driving the vehicle, almost striking the police officers. We discussed that in 157C, State's Exhibit. That's what I'm talking about, okay?
So,
You understand? To answer the record, okay?
yeah, I'm all right.
You
Yeah,
understand?
I seen some on paper, but I don't remember.
Okay. On that case, before going to Fulton County Jail, you went to Grady Hospital. Remember telling me that? And Jimmy Martin Jr. on recording?
I don't remember any conversation we had, Mr. Steele.
And it's me. I'm confident it's not you, so I apologize, but I can't hear you. I know you said you can't remember, but then there were other words. Can you repeat
What was your name? Mr. Steele, right?
Yeah.
Yeah. That's what I said.
What did you say, though?
I don't remember any conversation that me and you even had, sir.
Okay.
Get him still.
Remember on Sunday, January 22, 2023, approximately 11 o'clock a.m., listening to a jail call that Jimmy Martin Jr. played for you in my presence at the Kroger restaurant near your, Kroger grocery store near your home.
I don't remember any conversations I had with you, Mr. Steele.
Do you remember at that Kroger restaurant, Kroger grocery store near your home on the same date? You're all going to be the same date. Sunday, January 22, 2023, approximately 11 a.m. Jimmy
Sure
Martin
do.
Jr. and I introduced ourselves to you, and I made it known that I represent Mr. Jeffrey Williams, performer known as Young Thug, in this pending case. Do you remember that?
I don't remember any conversation we had, sir.
Do you remember being asked your telephone number by Investigator Martin and giving him a number? I'm not going to say it except for the last four numbers, 0730. Do you remember that?
No, sir.
Do you remember being asked by Investigator Martin your date of birth and giving it as June 22 of 1979 and stating that you're 42 years of age?
No, sir. I'm 44, sir.
Well, today you're 44. How old were you on January 22, 2023?
I was 43 then, I wasn't 42.
Do you remember me asking you, is it okay for Investigator Martin to record verbatim our communication there at the Kroger on that same date, approximately same time?
I don't remember any conversation we done had, sir.
Do you remember explaining that Dirty Red, or a gentleman known as Derek Dotson, was a good close friend of you?
I told you that.
One more time.
I told you that.
Do you remember that?
I don't remember that either, sir.
Do you remember explaining that Fred Prothro and Walter Murphy, DK, I'm saying, were with you on September 11, 2013?
I don't remember that either, sir.
Do you remember explaining that you were never charged with any crime involving Derek Dotson or Dirty Red? Do you remember that?
I don't remember that either.
And if you look at State's Exhibit number 157C as in Colette or Charlie, it's in front of you. You see that document?
Yeah, I've seen a lot of papers that you presented, but I don't remember none like that.
Okay, well, look at the State's Exhibit number 157C. It's right in front of you. You see it?
Which one is 157C, ma'am?
Man, read. Can you read?
Which one is one?
Read. Don't nobody want to read.
Want me
And
to look at it?
you can look at it. It's in evidence.
Act like you can't read.
The charges against you by the grand jury were dismissed as to anything involving Derek Dotson, like you said, on January 22, 2023. Correct?
I don't remember.
He sure do have on his jacket, motorcycle jacket. Ooh,
Do you remember explaining when talking about that entire incident involving Derek Dotson, Fred Prothro, Walter Murphy driving, screaming into the side of the laundromat, that Jeffrey Williams, or Young Thug, or Thug, was not involved in any way?
I don't remember the conversation, sir.
Do you remember
he was
then
involved.
explaining that they, meaning the detectives, tried to force Jeffrey Williams or Young Thug into it? Remember saying that?
Yep. Yep, they tried to put him in it, and he ain't even in it.
I think that was something you said, right?
No.
I don't remember that.
Okay. Do you remember explaining that the police wanted Thug in it and there was a lot of, quote, hype on the street?
I don't remember, sir.
Do you remember again emphasizing that Jeffrey Williams or Thug or Young Thug was not involved in any way on September 11, 2013?
I don't remember the conversation, sir.
Do you remember me referring to that jail recording between you and your wife made from the Fulton County Jail? And I asked you, what did it mean when you said, quote, they gave us a story to tell? Remember that?
No, sir.
Do you remember explaining that what you were referring to is that at the hospital, the police were telling us to lie, put Young Thug in on it, or face a lot of time? Remember saying that?
I don't remember the conversation.
Oh, they don't
Do you
like
remember
oh,
explaining
it's sad.
that you were the driver of that 2004 Nissan Altima vehicle, red vehicle, on September 11, 2013?
Oh, God.
But explaining that the police wanted you to make Young Thug the driver. Remember that?
I don't remember, sir.
Y'all, they're trying
Do
to
you
get
remember
Thug in
explaining
trouble.
on January 22, 2023, that you told the police on recording that Jeffrey was involved in this crime because you wanted to serve less time in prison?
No, sir.
Do you recall explaining that you made calls from the Fulton County Jail that you knew were being recorded to support your lie to the police that Jeffrey was involved on September 11, 2013?
No, sir.
Do you remember again emphasizing that Jeffrey Williams, I call him Jeffrey Williams, Thug, whatever you call him, was not involved at all with this crime?
I don't remember, sir.
Do you remember explaining that Derek Dotson died, God forbid, before your case came to the court, and therefore all the cases involving Derek Dotson were completely dismissed as to you? Remember that?
I don't remember, sir.
Do you remember explaining that you got 3 years to serve in prison for shooting 2 people in addition to this case?
I don't remember the conversation.
Do you remember explaining that you are not involved with any criminal street gang and that September 11, 2013 was not criminal street gang activity? Remember that? Basis.
Assuming facts not amendments in the state case.
That's what he said on recording. Oh, the objection. Do you remember saying that?
I don't remember still.
And Your Honor, I also object as to compound, because we don't know which question he was answering.
I'll sustain it as to
Now you can rephrase, Mr. Steele.
And then he wore that jacket in him in
Do
the
you
court.
remember explaining that you are not a part of YSL if it is a criminal street gang?
I don't remember, sir.
Well, are you part of a criminal street gang?
No, sir.
Do you have
Rebel.
any tattoos of gang activity?
No, sir.
Rebel man. You don't
You
see
remember
what
explaining that you only know Thug, Young Thug, Jeffrey through radio and seen him in the neighborhood?
Yes, sir.
Do you remember again stating that Young Thug was not in any vehicle with you?
So what's the objection?
Objection is to, form the question.
I stand the objection. You can rephrase, sir.
Do you remember explaining again on January 22, 2023, on recording to Investigator Martin and myself at the Kroger's near your home, that Young Thug was not in any vehicle on September 11, 2013 with you?
I may have, I don't remember the conversation though still.
Do you remember explaining that Young Thug, who I call Jeffrey Williams, never directed you to commit any criminal activity?
I don't remember.
Do you remember explaining that on the street, everybody wants to go against the man? They want to go against Young Thug. He's got the money. Remember saying that?
Your Honor, I object and ask that you bring in witnesses.
everybody do want to go against
Do you
him.
remember on Sunday, approximately 11:22, at Kroger's near your home, stating on recording to Investigator Martin and me that the street wants, everybody wants to go against the man, Young Thug. He's got money. Remember that?
I may have said that.
One more time.
I may have said something like that.
Do you remember explaining that all you know is that Thug is in the studio?
I may have said something. I don't remember though still.
Do you also remember giving your opinion that Derek Dotson killed himself? This is a 10-year-old matter and this should be over with. You remember saying that?
Something like that.
Mm-hmm. Truth coming out, y'all. Truth coming out. Truth alert. Now he talking. Now he talking.
When you were prosecuted for what's in State's Exhibit number 157C as in Colette or Charlie, when that case was prosecuted, you received what's called a sharing of information or discovery, you and your lawyer, from the state of Georgia. Remember that?
Never received one, sir.
Okay. Do you know whether your lawyer received one?
Objection is to speculation.
If you know.
I'll rule the objection.
I never seen a discovery.
I cannot hear.
I never seen or had a discovery.
Have you ever seen any of the memorandum, recording, note of your meeting with the detective at the hospital on September 11, 2013?
Objection, assuming facts that are not in evidence. There's no good faith basis for that. There's no such,
You all come on up. Come on.
He finally agreed. Woo, we ain't got that long, y'all. We ain't got that long. He finally opened up that mouth. They don't like Thug, y'all. So a lot of people don't like that young man. His name, they just mad because he got his own, he in his own world. And they trying to put him all in, mixed up in all that mess. Sit up there and lied to me he was in the car. He wasn't even in the car. They don't like Thug. Poor thing. Let me skip the thing. Y'all, come on. Don't take that long.
Chris, you're going to get some more tape. She's coming, coming off. All right, ladies and gentlemen, we got to take up some other things. And so what I want to do at this point in time is go ahead and recess for the day. Okay. So, Mr. Bean. I need you to be here for 10 o'clock on Wednesday, March the 13th.
Yes, sir.
10 o'clock, Wednesday, March the 13th. You good with that?
Yes, sir.
Okay. As I mentioned earlier, don't discuss your testimony with anybody except the attorneys in this case,
Oh,
okay?
so he ain't got to come back until
All right,
next
we'll see you
Wednesday.
then, okay?
So yeah,
Okay.
he don't have to come back until next Wednesday. Wonder why. Ugh, they gonna give him a break, huh?
Okay. All right, ladies and gentlemen, jury, let me go ahead and take up a couple of things with you. Okay, as you know, we are going to be in recess tomorrow through next Tuesday. So that's the 5th through the 12th. So we good for that? Okay, now, I've shared with council that I'm in receipt of some correspondence from you about that you've taken an unscientific poll amongst yourselves, not in violation of the court's admonitions, but to ask about spring break and parentage and other things. Is that right? Don't be bashful now. Come on now. I got paper, okay? So have a good faith basis asking you this, all right? So is that your desire between the 1st and the 5th of April to be down? I think a majority of you wish for that to occur.
Yes.
Okay, all right. I've talked with our lawyers, and I think that would be appropriate, okay? So, I wanted to address it to you now because I know you all want to plan, all right? But don't ask me for nothing else, okay? Nothing. Okay, all right, as long as we're good with that, okay? Now, I'll do it, and I think it's appropriate for you all to be able to spend that time with your for those of you that have school age children and the like. So we will be taking up other matters during that particular period of time. Okay, fair enough. All right. There's another person that sent me a note talking about the 20th of March. Don't identify yourself, okay? But I feel on pretty good authority that particular morning you will be able to make that appointment that you need to make. But I've told all of you, please make your appointments on, I think I give you enough time so that we don't have any, kind of discrepancies with this as much as we can do it. Okay. So, try as much as you can. I mean, I know life happens and we'll flex on that and we appreciate that. But to the extent that you can, make your appointments or on the other days it will be kind of down or have administrative time, please go ahead and do so, okay? So, huh?
In recent, a couple of us have been getting some pushback, even though you have been giving us notice.
Pushback from who?
The doctor's office. Some of them are booking out like 8 weeks out.
I understand that, and we'll work with you, okay? I understand that. I'm giving you a hard time, but but to the extent that you can, please do so. But we'll do whatever we can with that, okay? But if you can, what I'd rather you do, if you do have an appointment, make it first thing in the morning or as late as you can in the afternoon, so we can go ahead and take some. I can release you earlier, have you come in late, okay? So to the extent you can, I mean, as I tell people all the time, life happens, and then you do your various vocation.
All right, y'all.
we'll do
So
what we
far
can
with
for that,
that.
all right?
Let me see.
Okay? All right.
Since they don't got rid of the jury.
Anyone? All right. Okay, so folks, all right, as to the ministerial, as to the scheduling. Okay. Since our jury has left us and it's advocates and clients and the court, the last thing that we were talking about at the bench was in reference to conversations that were supposedly made by Mr. Bean at the hospital. And I believe that we are in disagreement as to a couple of things. One, whether or not the statement was made referencing an event at the hospital. So I want to say that in order
Spinning all
to
over with that dress on. Sit down.
ground zero on that,
Jesus, know that camera looking at you.
we'll have to let Ms. Weaver prepare or at least the transcript reference to the testimony of Detective Velasquez in regards to his testimony on this particular statement made by Mr. Bean's statements. Okay. That also may have to be
Girl, stop fussing so much.
cross-referenced
Listen to
along
the
with, the interview
judge. Y'all
of Mr.
fuss too
Bean.
much.
as well as the purported statements that were made to Mr. Steele and his investigator. So, councils, I'm going to let you all kind of take a look at those three sources and be prepared to kind of talk about those when we come back on the 13th to see whether or not, in
It's
fact,
not even spring break
that
yet.
is, if we've been able to find some particular granularity
Wait a minute.
on those particular statements in terms of whether or not.
All right, y'all. In other words, I thought spring break is the first week. It used to be the first week in April. But he act like it's start next week. And it don't. It's not in March. So I don't know about that. It's supposed to be the first week of April, but he's saying they're not gonna come back until the 13th. 13 is next Wednesday. I wonder what Atlanta out for. Atlanta is out for. I wonder why they not. I don't know. Maybe I'm misunderstanding. But anyway, yeah, the day trial was pretty good. Day 41. This boy sitting on the stand just lying. He did time for what he served time for what he did. And he was the driver. And John Thug wasn't in the car at all. Okay. It was Murphy, it was Freddie, it was Bean. I think them the only three. It was three. I thought it was four of them in the car. The tall boy who was in the front seat, who was like 7 feet, 6'8" or something like that. He was real tall. He was sitting up in the front. And his seat go all the way back. So anyway, they had two of them guys on the ground. So two ran. So Thug wasn't in the car, y'all. Thug wasn't in that car. But everybody don't like that man. The city don't like him. And just because probably the only reason why they don't like him because he helped. They thinking that he helping the criminals, but he's not. He was helping them young guys. A lot of them young guys, make a little money on the side. Y'all know how it is in Atlanta. During that time, struggle was hard. Them boys were, going to school, want to be rappers. They need money. They mama didn't have it. And you have to put money down on stuff. So I'm not gonna agree with selling, doing stuff like that. It's right, but them boys have to do what the boy have to do. Man had to do what a man had to do out there on the street. So, you know, because a lot of half the time, most of the parents was on the street, you know, getting high off their own supply. So it's a lot of struggle in Atlanta back then in 2013, 12, 11, 10, 9. So it was kind of bad back then. But what we'll do is we'll excuse me, y'all, I had to breathe for a minute. Excuse me, I'm sorry. The Adrian Bean, no, he's not being honest. Now he liked to tell he was tearing it up at the end. He was tearing it up at the end because he can't get charged for. They don't want him to get charged for what he already done been charged for. See, he done did his time for his crime. That's why I understand, and I'm gonna say it again. I don't understand why are we here today with a RICO and they already did the time. Why are we here? Why are we doing a RICO, wasting the taxpayer money, and they already done did their time? Unless we go down the road on another different area of the case, because the case gonna get stronger and stronger. Right now, we're in the weak link based on what's going on right now. So it haven't really hit hard yet. Okay. But we're gonna be back tomorrow because I don't understand what's tomorrow. Tomorrow we are in school tomorrow. So I don't understand what's tomorrow, why he had to come at next Wednesday. I don't understand what's going on next Wednesday. It's kind of weird though. I don't understand. But if they come on tomorrow, you know, we'll be there. We'll be right here. And I want to thank Mamad for being here. I want to thank the viewer for watching and understanding the case and being involved. And another thing I want to say too, I always read. This first thing you need to do when you ready to come, so you won't get lost on the cases. If you've been with me from day one with the Young Thug case, we've been on this case since it started. I always read the title before you come in, then you won't have to ask too many questions. Okay? Just read. It'll tell you what the name of the what content we come on, grown people. Come on, grown people. My page is blocked from the kids, okay? Mine is 18 and up. So y'all read the title instead of coming in here you know, asking questions like what are y'all what is this all about? Pay attention. You're grown people, you know, read. You know it's Young Thug. That's what I got up there on that title. Young Thug trial, okay? So y'all go ahead on and let me get ready to put something else out there for y'all. Y'all like, share, and subscribe. And another thing, I need for y'all to get them lights up. Y'all come in here with an army of people, be like 15 or 20 of y'all coming in here, flying over here. 15, 20. And then hit the like button. Y'all go leave him, then y'all go sit in somebody else's chat. And then I'm not going to beg you for the lights now. But as a female and doing what I'm supposed to be doing over here, y'all should appreciate that I'm doing what I do. And my mom's doing the best they can too. Y'all, you know, don't, you know, just... It is what it is. Y'all like, share, subscribe. I'm out of here.